Okay, good evening, everyone. Welcome. I am delighted and honored to welcome you to this book talk featuring Judge David Tatel speaking about his new memoir, Vision, a memoir of blindness and justice. My name is Joanne Lynn, and I am the Executive Director of the Washington Lawyers Committee for Civil Rights and Urban Affairs. As you can tell from this terrific crowd, Judge Tatel is greatly admired and adored. It is such a joy to see so many of you from different chapters of his life, judicial clerks, judges, co-counsel, colleagues, family, and friends. It is very fitting that we are all gathered here at Sidley Austin, one of the nation's leading law firms and with an outstanding pro bono and civil rights record. Sidley, Chicago is where David Tatel cut his teeth as a young lawyer and budding civil rights litigator. Thank you to Sidley, DC for generously hosting this book talk and making this special event possible. Special thanks to Sidley partner Mark Guerrera, standing in the back, a stalwart board member of the Washington Lawyers Committee, and to Sidley partner Jenny Clark, seated here in the front row, a Tatel clerk who will be in conversation with the judge about his new memoir. We know that a major event like this is possible only through the intensive hands-on work of Sidley's IT, AV, reception, logistics, and janitorial staff. Thank you to Sidley. If there is one person whose name is intertwined with the lawyers' committees, it is Judge David Tatel. In 1968, he became the founding executive director of the Chicago Lawyers Committee for Civil Rights, and later went on to direct the National Lawyers Committee for Civil Rights under law. Judge Tatel also served on the boards of both the National Lawyers Committee and the Washington Lawyers Committee for Civil Rights. Today, I am joined by my friends and colleagues, Damon Hewitt, Executive Director of the National Lawyers Committee, and David Shapiro, Executive Director of the Chicago Lawyers Committee. Judge Tatel, on behalf of Damon, David, and myself, thank you for all that you have done to found, lead, direct, and guide the many lawyers' committees. We are joined today by several honorary guests, including relatives and friends of Judge Tatel who have traveled from as far as California. And of course, we are joined by his beloved Edie Tatel and Vixen Tatel. Thank you for gracing us with your presence. Finally, I would like to thank my colleague, Claire Stalder. Is she in the room? Claire, she's right here. Claire, could you stand and be recognized? Claire planned and organized this entire event with the help of many at Sidley and the Washington Lawyers Committee. Thank you to all of you. And here's what to expect for this evening. In a moment, we will hear from Damon Hewitt, and that will be followed by Joe Sellers, who is the founder of the civil rights practice at Cohen Milstein. Jenny Clark will then be in conversation with Judge Tatel about his memoir for about 20 minutes. And we will then open up the rest of the evening to a discussion with all of you, where you will have the opportunity to pose questions of Judge Tatel. Following the book talk, the judge will be signing books, and all are welcome to enjoy this wonderful Sidley reception. And with that, I'll turn it over to Damon Hewitt.
Thank you, Joanne. Good evening, everyone. I want to once again thank the great folks at Sidley for hosting, and we're proud to co-host, but special kudos to the Washington Lawyers Committee for really being the laboring oar and the visionary, no pun intended, on the book title, to make this evening happen. I see so many familiar faces, and it brings me full circle. I see Dan Corman, Judy Winston, and other people, and it brings me full circle because I am a direct beneficiary of what David Tatel has built. I was a summer intern at the National Lawyers Committee in 1998, 26 years ago. And in that time, I've been able to come full circle and be a part of this stalwart community of jurists, of activists, of warriors for justice, seeking truth, leveraging the rule of law every step of the way. Now, if you're familiar with the origins of the National Lawyers Committee and the committees across the country, you know that our motto of advancing civil rights and justice is all about leveraging the power of pro bono in the private bar. The Lawyers Committee makes a way for the private bar to get involved in the work. The Lawyers Committee makes the way, but the lawyers make the committee. I like to say that the pro bono network and the staff of the allied organizations are the best of the bar. Well, David Tatel is the best of the best. So he has a record of service that is unparalleled. He served, of course, as the founding director of the Chicago Lawyers Committee. And in '71, he came to DC. And I think it was even before he led the National Lawyers Committee, he led under the leadership and guidance of Lloyd Cutler, the 1% program. This was an initiative that transformed the landscape of pro bono in the private bar. You see, there were lawyers committees in multiple cities, of course, and affiliates and offices, but not every city had one, still to this day. And in the cities that didn't have that leveraging, that presence, the 1% program challenged law firms to commit themselves to devote at least 1% of their resources to civil rights and poverty cases referred to them by the National Lawyers Committee. I'm so happy to say and grateful that firms in 45 cities answered the call. And that was under the leadership of David Tatel. Judge Tatel, of course, served as our executive director at the National Lawyers Committee for between '72 and '74. And Joe Sellers, I think, will talk a bit about some of what he did during that time. But what's important is that he didn't just push paper and manage. He actually litigated cases alongside everyone else. And he litigated, in particular, a school finance case that is very notable. At the same time that the Lawyers Committee was taking on even more cases with in-house staff, he never let up on leveraging the power of the private bar. It was really through his leadership in those critical years after the second Reconstruction, after the major legislation of the Civil Rights era, that we really started to see lawyers, whether it be the fee shifting provisions or whether it be the fact that there was new legislation on the books, period, to advocate, we really saw the private bar getting more and more involved. And that evolution happened during Judge Taylor's critical 2 years at the helm. Even after leaving the helm of the National Lawyers Committee, he continued to serve on our board. We hooked him back in a few years later to be co-chair of our board alongside the late Robert F. Mullen, after whom we've named one of our pro bono awards. And even after his time as co-chair ended, he continued to serve on the board up until he ascended to the bench. Forgive me for the ascent, Judge. I know you don't like grandiose language. But I want you to know that as a jurist, as a skilled lawyer, as a strategist, and as an informal and sometimes formal mentor to many, Judge Tatel's life and career has been one of consequence, a life of impact, a life of commitment, a life of service. We're all grateful and we're all better for it. Thank you so much, Judge Tatel. I will now turn it over to one of my favorite co-counsel ever, Joe Sellers. And here's Joe.
Thank you, Damon. It is an honor and personal pleasure to introduce Judge David Tatel, although he really needs no introduction in this room. While Judge Tatel's distinguished service on the DC Circuit for 30 years is most widely known, his work as a civil rights lawyer at private firms, civil rights organizations, and in the government reveals a great deal about David Tatel, as it involved work he chose to undertake rather than rulings in cases to which he was randomly assigned. When Judge Tatel began his legal career as an associate in the Chicago office of Sidley and Austin, his interest in civil rights, and especially in the desegregation of our nation's public schools, was kindled early by his involvement in a pro bono case which led to the integration of the Waukegan schools in suburban Chicago. That work and Judge Tatel's service on the Chicago Riot Study Committee, in which he explored the cause of urban unrest in 1968, led to his selection, as you've heard, as the first executive director of the Chicago Lawyers Committee for Civil Rights. Thereafter, Judge Tatel worked in the Washington, D.C. office of Sidley Austin, where he continued working with the Lawyers Committee on pro bono matters, which led to his appointment as the director of the National Lawyers Committee. In his 2 years there, the committee challenged racial discrimination in a broad range of areas, including employment, housing, school finance, and attendance policies, and apartheid in South Africa. Then he joined the firm then named Hogan and Hartson to head its community services department, where he headed a team that was engaged full-time in pro bono work. Perhaps the most notable work at that time he was representing the NAACP and residents of Mississippi who were alleged to have engaged in an unlawful antitrust conspiracy when they boycotted local businesses for failing to hire Black employees and opposing the desegregation of the local schools and integration of the local police department. Their work led to the landmark ruling by the Supreme Court in NAACP versus Claiborne Hardware, which held that boycotts undertaken to promote social justice goals are protected by the First Amendment. While still at Hogan and Hartson, Judge Tatel also squeezed in service as the first general counsel of the Legal Services Corporation. With the inauguration of Jimmy Carter, Judge Tatel was appointed to head the Office of Civil Rights of the Department of Health, Education, and Welfare. The most pressing challenges for that office involved accelerating the desegregation of the nation's public schools, as well as interpreting and enforcing the recently enacted Rehabilitation Act, which mandated publicly funded entities such as schools provide protections and accommodations to people with disabilities. After 2 years at HEW, Judge Tatel returned to Hogan and Hartson to start an innovative and highly successful practice representing urban public school systems in their desegregation efforts, which led to the first school plans in Kansas City, Missouri, and Milwaukee, Wisconsin, that integrated urban and suburban school systems. Then lightning struck. The retirement of Justice White, followed by the appointment of Ruth Bader Ginsburg, the seat on the Supreme Court, created a vacancy on the D.C. Circuit, to which President Clinton nominated him. After his confirmation by voice vote, he joined the D.C. Circuit, where he served for 30 years. While Judge Tatel's written opinions speak for themselves, one in particular is noteworthy for this group. He authored the decision in Shelby County versus Holder, upholding the validity of the preclearance requirements of Section 5 of the Voting Rights Act. Notwithstanding that Congress had repeatedly reauthorized this section of the Act as recently as 8 years before this latest challenge, the Supreme Court voted 5-4 to rule that the preclearance requirement relied on outdated evidence and therefore voided the requirement. Judge Tatel's opinion is an eloquent testament to the singular importance of the Voting Rights Act and the preclearance requirement in particular, and to its importance for our democracy. He issued numerous other noteworthy decisions, some of which he discusses in his book, along with his evolving philosophy of judging that I recommend the entire judiciary read. After retiring from the court, Judge Tatel has returned to Hogan Lovells to continue engaging in pro bono work. An introduction of Judge Tatel would not be complete without noting, as he describes in his book, the courageous and often difficult efforts to reconcile his diminishing eyesight and eventual blindness with his effectiveness as a lawyer and jurist. He shares this very personal journey with us in his book, as few have done before. Before turning the program over to the discussion of Judge Tatel's book, I feel compelled to note that he and I discovered in our conversations that we each grew up as lawyers at the Lawyers Committee, he at the National Office and I at the Washington Committee. His service to the Lawyers Committee on the staff and on the boards of the National and Washington committees has provided an invaluable and enduring mark that continues to guide our work. On behalf of the communities of the National and Washington committees, I want to say to Judge Tatel, welcome home. Judge Tatel is joined today by his wife of more than 60 years, Edie Tatel, who is known in other circles as Dr. Tatel for her significant accomplishments in education. And of course, he's joined today by Vixen, who came to Judge Tatel about 5 years ago at the urging of his grandson, and whom he describes as revolutionizing the ways in which he accommodates his blindness in both large and small ways in his life. We are very fortunate that Jennifer Clark has agreed to have a conversation with Judge Tatel about this book. Jennifer was a law clerk of Judge Tatel in the 2008 to 2009 term, after which she worked in the office of the Solicitor General and then clerked for Justice Ruth Ginsburg before coming to Sidley and Austin, where she is a member of the firm's Supreme Court and Appellate Group. Jennifer?
Judge, this is the mic. We're all set. Thank you very much. Hi, everybody. Judge, it's such a delight to have this opportunity to chat with you about your wonderful memoir. There's way, way, way more in this book than we can possibly cover in the amount of time we have. So I'm just going to dive right in. One of my very distinct memories clerking for you is when we would get a new case in, it didn't matter what the subject was, you would pick up the briefs or you would come to talk to us and you would say something along the lines of, "Isn't this interesting?" Now, I have to admit, I may have exchanged some quizzical glances with my co-clerks over certain FERC matters when you were so enthusiastic, but I was really thrilled to learn in the book where this comes from. So you talk in the beginning of the book about your early childhood and your father's scientific endeavors. And in describing him, you say, "He made me interested in everything." And I know that's true, but I wonder if you could tell us a little bit about that time in your life and about your father and what sparked this lifelong curiosity and fascination you have in just about anything, even FERC.
Jenny, I will answer your question, but first, I want to say a thank you to, is this working? Yeah, okay. I want to just thank Joanne and Damon and Joe and everybody at the Lawyers Committee for organizing this event. As Joe said, I truly grew up in the Lawyers Committee, and I've had many book events and interviews, and there's none that I've looked forward to more than this one. And Joe is actually right. I feel like I've come home. So Jenny, your question. I grew up in the 1950s, late 40s and 50s. My father was a physicist. He came to Washington to work on the war effort, and I was as a kid. He took me to his lab. I was interested in science. My sister Judy is here. Where's Judy? Judy's over there. We lived in a house of more or less science fair projects. I would go to the lab with my dad. I went on expeditions with him. I wanted to be a scientist, and I was just fascinated with it. And even though you didn't ask this, even though I changed directions when I went to college and was more or less captured by the turmoil of the 1960s, science has always been a very important part of my life. And in fact, I try to explain several times in the book the way in which I think proper judging is a lot like proper science.
Well, we're going to get to that a little bit later, but I'd actually, since you've brought it up, why don't you tell us a little bit more about that? In what way do you see the parallels between scientific endeavors and judging?
Well, maybe I'll answer your question with a quick story. When I was 15 years old, my dad took me on a 2-month scientific expedition to Peru and there was a group of 7 or 8 scientists. They were exploring the thickness of the Earth's crust. They were pure scientists trying to get answers to difficult questions. And every night they would sit around after they had done a day of scientific expeditions. I had my own little scientific equipment to use, and they would talk about their work. They would explore their data. They had a hypothesis. They would listen to each other. They would debate, and the next day they would do the same thing. And as I look back on my life, having spent all these years on the DC circuit, that was my first exposure to collaborative thinking. And Jenny knows from having clerked on the DC circuit how collaboration is critical to the judicial process and the way in which scientists apply the laws of science to the facts they learn. Judges apply the law to the facts of the case. They're very similar in the sense of their objectivity and their collegiality and the basic requirement of open-mindedness to do good science and to do good law. They're very similar.
So when you, Judge, you mentioned that when you went on this expedition to
Yeah.
Peru, you were 15.
Yes.
And this was right around the same time, I think just not very long after this, that you first were diagnosed with the genetic condition retinitis pigmentosa, sorry.
Jenny, I never considered either.
And at the time, you mentioned in the book, this was just a mere 5 years after this discovery of the double helix structure of DNA. And I wonder what the experience was like in getting that diagnosis in a time when not much was understood about it and at such a young age. And how did that affect your sort of your teenage years, if at all?
So little David Tatel could never see at night, and nobody understood why. And my parents made me eat lots of carrots. And I still like carrots. But that was a major problem. No one knew what it was. They took me to various ophthalmologists, and no one really knew what it was. And but I could function pretty well. One of my most vivid memories of the consequences of this is not only the difficulty of functioning in the dark, but I was a totally obsessed baseball kid. And I remember when I was probably in the 4th or 5th grade, getting hit by a ball that I didn't see coming. And I had a sense that something was wrong. Anyway, when I was 15, my mother took me to the National Institutes of Health, where they diagnosed me with retinitis pigmentosa. It's a genetic disease. They told me they didn't really know much about it at the time. They did know that people with RP, that eyesight would slowly decline, that it would plateau from time to time, and that some people would lose their sight and other people might not. But that's pretty much all they knew, and that I should eat carrots. That was kind of it. I went to every year I went back and got examined, and through the exams I could detect declining sight, mainly peripheral vision. But I was a kid and had a lot of friends, and we had a really nice life in Silver Spring. And when you're young, you're optimistic, and it never occurred to me that I might actually lose my eyesight someday. I just didn't think about it that way. And I spent most of my time and energy basically trying to cover up the disability. I wanted to be like my friends. I didn't want to be different. And when I got to college and law school and started practicing at Sidley, I kept covering it up as much as I could, because I thought that I wasn't sure how having that kind of disability would affect my future employment prospects.
So you went through high school and then went on to college in the early 60s.
Right.
And there's a section of the book that I've remarked to a couple of people has a almost Forrest Gump-like aspect to it, because you had quite a series of amazing experiences and encounters during that period of time here in Washington. And I wonder if you might tell us a little bit about being a college student, a young adult in the 60s, and how that shaped kind of your thinking about the world and your career.
Yes. College did for me what college is supposed to do. It was an extraordinary time for me. I was at the University of Michigan. This was in the early 60s, civil rights movement in the South. The papers were constantly covering the freedom rides, the demonstrations, the boycotts. The University of Michigan was a center of protest and excitement. And I was fortunate, very fortunate, to be one of thousands of college students who got summer jobs in the Kennedy administration. President Kennedy believed in public service, and he brought thousands of college students who were sophomores and juniors and to Washington, and we had real jobs. Well, strike the word real. We had jobs that they paid us to do. I was in the labor department. My friends were in justice and defense and all over. And the president spoke to us at the beginning of the summer and talked to us about the importance of legal service, of public service, and we met with members of the cabinet. And the message was There's nothing more noble and more important for American citizens than serving your country. That's what we heard. And at the same time, we're all watching this amazing civil rights movement and the role of lawyers and the Justice Department. And then to top it all off, in 1963, the summer of '63, my second year with the Department of the Labor Department, that was the March on Washington, and I walked from Capitol Hill down to the Lincoln Memorial, and it was a really hot day, and my friend who I was with, we sat right on the edge of the reflecting pool, stuck our feet in the water, and we heard Martin Luther King's "I Have a Dream" speech. I mean, it was an amazing summer, and this had just a huge impact on my career because I was completely into the civil rights issues, and I wanted to be one of those Justice Department lawyers when I grew up. That was my mission when I was a college student. That's why I left science behind.
So let's skip ahead a little bit,
Yeah.
just in the interest of time. We're going to skip right past law school. We're going to skip past your stint with Sidley, which was mentioned in the introductions, because we really want to get to your involvement with the Lawyers Committee.
Right.
Now, as you mentioned, and you say in the book, you grew up with the Lawyers
Right.
Committee. So tell us how that came to be, and what do you mean by that? What do you mean that you grew up in the Lawyers Committee?
Well, let me just tell one aspect of how I got connected to the Lawyers Committee, because just as my work in Washington in the '60s was seminal in how I thought about things, so was what happened to me in the late '60s. So Edie and I were living in Chicago. I was with a law firm, Sidley. Edie was teaching at Harlan High School on the South Side. We had, we loved Chicago, and I loved my work, and Edie loved her teaching. Excuse me. But in April, Martin Luther King was assassinated, and the city was racked with terrible riots, really destructive riots. And as a result, the mayor set up a commission. This was the mayor, Richard Daley, to explore the causes of the riots. And the law firms were asked to volunteer associates to be investigators. And Sidley knew I was interested in this, and they volunteered me for this job. And I spent the summer after the riots. By the way, this was the summer of 1968. So it was not only that was a city recovering from the riots, but we had the Democratic Convention. It was a pretty extraordinary summer in Chicago. In any event, as a result of this summer, where I spent a huge amount of time interviewing students and teachers, and my interest in civil rights grew. And I went back to Sidley after that, and I really liked my work, but I really wanted to do civil rights work full time. Fortunately for me, at that very moment, the Lawyers Committee, as you know, which had focused mainly in Mississippi and Alabama, was expanding nationwide at the request of President Kennedy. The purpose of this expansion was to bring, the energy and skills of lawyers to work on the problems identified by the Kerner Commission. And fortunately for me, I was hired to be the first executive director of the Chicago Lawyers Committee. And the Chicago Lawyers Committee, David Shapiro's here. He's running it now. Theory then is the same as it was now. We developed projects and referred them to law firms. And it was just a wonderful year and a half. I loved the work. I learned a huge amount from the partners who were on the board. And it was the beginning of my growing up in the Lawyers Committee, the Chicago Lawyers Committee. It was great.
One of the things is amazing about that aspect of your time is just how small the operation was to begin with when you came in. It was me, a secretary, and a Xerox machine that Sidley gave us. That was it. Oh, I had a desk. That was all it was. And you were working with lawyers from various firms in the city and you were working not only to get people to take on these cases, but you were actually getting to work on the cases themselves as well, right?
Yes, it was perfect for a young lawyer because I was developing cases for the firms, but working with the firms on the cases. So I had this unique opportunity to hang out with some of Washington's best litigators. I mean, it was pretty extraordinary opportunity for someone who was, I was only, 27, 28 years old at the time. And here I am sitting in a courtroom with some of Chicago's best lawyers. It was really an enormous learning experience for me.
And then could you tell us about the transition or the move from the Chicago, I think that we'll skip a couple steps in between, but from Chicago to the National Committee and your work?
Yeah, well, Edie and I grew up in Washington, as you know, and we always wanted to come back to DC. And Sidley was very welcoming about that. I wanted to go back to Sidley. And they said, well, why don't you go to the Washington office? By then, Edie and I had two little girls. And it was, coming back to Washington and working with Sidley was really fun. But I stayed very much involved in the work of the Lawyers Committee. I had a big civil rights case of my own while I was at Sidley. And then after a year or two, the director of the committee, Jim Robertson, who like me, grew up in the Lawyers Committee, and we both ended up federal judges together. It was quite extraordinary. He was the director of the committee. He decided to return to his firm, Wilmer, and Lloyd Cutler, who was the co-chair, hired me to be the national director. And that's how that happened. So I continued growing up in the Lawyers Committee.
So, Judge, over this whole period of time that we've been discussing, your vision continued to deteriorate. Right. And you've mentioned already that you had already, as a younger person, begun to develop some tricks and ways to navigate around it, and in some cases to disguise it. And I wanted to ask you about one of these ways in particular, which, no, it's okay. In clerking for you, I was often just dumbstruck by your memory. And you could remember that, you would say things like, let's go back and change the word on page 4, 2 sentences from 2 lines from the bottom of the page. And not only the substance of the piece of writing we were working on, but the page it was on and where on the page. And at the time, I just thought, well, you just have always had this unbelievable memory. And so I thought, well, there's nothing I could ever do to get anywhere near that. So I just was pretty relaxed about it. But now here I learn in the book that your memory actually developed as your sight was deteriorating. And I found that fascinating. I wondered, was that something that you noticed as it was happening? Was it something you had to work on, or did it just?
Well, the human brain is a totally amazing device. I mean, when I was a kid, the only thing I could remember was basically batting averages. I didn't have any better memory than anybody else, probably worse. But the human brain is remarkably plastic. And anybody with a disability of any kind will tell you that the brain adapts. And because it was harder and harder for me to read, and therefore it was more important to retain what I heard, it's just inevitable, I think, that the brain would accommodate that. I mean, by the time in my mid-30s, when I was director of the National Lawyers Committee, I basically moved from functioning as a sighted person to functioning as an unsighted person. I learned Braille. I started using readers, and I noticed that I could write a half-hour speech, and deliver it from memory. But that's just because the brain is so unbelievably elastic. It compensates for so many things. I think that's also true of hearing. And I've read a great deal about this, and I'm far from the only person who has experienced this. Here's the other side of it. As the world has become more digital, I'm less dependent on memory because I can read so much of my own. There's no way I could give a half-an-hour speech by memory anymore. My memory has gone back to what it was when I was 15 years old and concentrating on batting averages. It's true.
Wow. So if we could jump ahead again and talk about your appointment to the DC Circuit.
Yes.
Now, you were at Hogan.
Yes.
You had founded and you were running their education practice when you were appointed. Yeah. So when coming from private practice, having never been a judge before, how did you figure out how to be a judge, and how did you decide what kind of a judge you wanted to be?
That's a great question, Jenny, because and I write a lot about this in the book, but the short version of this is that, number one, yes, I hadn't been a judge, but I had been in the federal courts for 30 years, and I was greatly influenced by my professors at Chicago about the role of the courts, and we studied judges and cases, and I came with a pretty good idea of what I thought the courts should be. But the fact is, I hadn't been one. I spent the summer, I was nominated by President Clinton in May, and my confirmation hearing wasn't until early October. It sounds like a long time, but not today. I mean, compared to today, it was like lightning. So I spent the summer reading judicial biographies. I thought, what better way to think about this job I'm getting into other than to read about some of the great judges? And I read quite a few of them, and I liked many of them. The two that really resonated with me was a wonderful biography of Learned Hand by Jerry Gunther, who was a dear friend of Edie's and mine, and also a biography of Lewis Powell by a professor at the University of Virginia. The Powell biography I really liked because he, like me, went straight from a law firm to the court, he the Supreme Court, me the DC Circuit, and his description of what his first few years were like and how difficult they were gave me some confidence that, you know, maybe I wasn't, that I would be able to do this too. But the key thing about the two judges is that I really took to their concept of judicial restraint, of the fact that courts have limited power. They need to protect the separation of powers by using their power sparingly. Both justices talked about the importance of precedent and all the tools that judges use, and they found those rules, although constraining, satisfying, because following those rules made them believe they were functioning as judges, not as policymakers. And I really liked that. It made sense to me. And as I say at the end of that chapter, the rest of the book, it's one thing to read biographies about judges. It's another thing to go actually figure out how to do it. And that's what I spent the next 30 years doing. And as I look back on it in my own career, in my own cases, I like to believe that I did follow those two great judges. I hope people will read my cases and my decisions and see in them the effect of those two great judges and many others like them. They weren't the only two, but those were the ones that I happened to focus on during that time.
So, judges, as a member of the Tatel Ginsburg clerk cohort,
Right.
I would be remiss if I didn't ask you about Justice Ginsburg, whose seat you filled on the DC Circuit. Now, I know you had multiple clerks that went on to clerk for the justice, but what was your personal relationship with the justice like after you took your seat on the bench?
Well, I always thought that she kind of had her eye on me, because I was in her seat and she wanted to make sure everything was okay. She never said that to me, but I like to think that we became friends. Justice Ginsburg and Edie and I had quite a few dinners together. Best thing is she took lots of my law clerks, like Jenny and many others, right?
Yeah, that's right.
And that always made me feel very good that she liked my law clerks, that she thought they were well trained enough to clerk for her. Ruth Ginsburg, well, let me just say this. Jenny and I have this, you'll see when you read the book, role models were a big deal in my life, in my whole career. And Jenny and I share this wonderful role model. I mean, I think Ruth Ginsburg is one of the great. I mean, her career before becoming a justice was just extraordinary. I mean, she was a Thurgood Marshall of the women's movement. And I'd so admired her work as a justice. I thought she was a brilliant writer. And I actually found, I remember from time to time, I'd read a Ginsburg clerk and take it down to my law clerks and say, read this, not for the substance, but for how it's written. I mean, she was a master. I think what you want me to get to is Justice Ginsburg's decision not to retire. I talk about that. She, when all the pressure was building on her to retire, from time to time, she would complain to me about it because I just happened to be next to her at either a dinner or reception. and she trusted me. She did not like being told by her friends and non-friends that she should retire. She thought Justice Stevens stayed until he was 90, and she didn't see why she couldn't either. And the memory I have most is one night at dinner at our house. It was Edie and me and Ruth and a couple of other people. She was really quite upset at the pressure that was being put on her. I never took a position. I would never do that with her. I didn't have that. There was no way I was going to second guess. I was just trying to be a good person to listen to her. You know, I think obviously she rolled the dice and lost. I think she never told me this, but I think that Justice Ruth Ginsburg, I think what she had in mind for the end was retiring and having the first woman president appoint her successor. I think that's what she wanted. And sadly, for her in the country, it didn't turn out that way.
So let's take a second and just moving from Justice Ginsburg and then her, you mentioned her ability to write. And I think you quote from her dissent in Shelby County
Right.
in the book, which is, I think, a pretty well known example of her writing. And in the book, you talk about a lot of the many cases. I mean, you obviously were on many important cases over 3 decades on the bench, but you devote a whole chapter to environment and you devote a whole chapter to voting rights. And I wonder what your thought process, just taking voting rights as an example, what was your thought process in focusing so heavily on those in the book? And maybe you can tell us a little bit about Shelby County.
Yeah, sure. So when I started this book, I decided that I wasn't going to write. I wanted to share my views. I wanted to talk about blindness, and I wanted to talk about the courts. And on the court side of it, I had been on the court for 30 years, and I thought, I think I have some observations that I would like to share. But I made two decisions about it. One is I was going to focus not on the Supreme Court in its broadest sense, but just on the part of the court I knew best. I thought that if I had any credibility, it came from being a federal judge on the DC Circuit, sitting on certain cases. And it was through those cases that I had the best sense of the court system and the Supreme Court. So I decided to limit it to those. And secondly, I was determined to write about the court as an institution, not about individual members of the court or motivation or anything. I wanted to focus on the Supreme Court as a judicial body. I did that same thing at the beginning of my career on the DC Circuit in the Madison lecture, where I focused on the Rehnquist Court, and I wanted to do the same thing in this book and focus on the court as a judicial body and its judging and not anything else. So as I look back on all my work on the court, it became quite clear to me that the environmental cases and the voting cases were just dominant. Cases are assigned randomly at the DC Circuit. And I got on so many of those cases, some reporters questioned whether it was really random, but it was. I was on, Northwest Austin, Shelby County, and then the Texas case. And that was all totally random. Same thing with the big environmental cases. The assignment was random, but as a result of being put on those cases, I actually began to develop some serious ideas about those aspects of the law and especially the Supreme Court. And so I picked those two. And to me, they are those two, just to talk about this. Well, let's take Shelby County, for example. I mean, as Damon said, I wrote that opinion. And I also wrote the earlier one, Northwest Austin. Got reversed in both. I think, well, let me say as a judge, the panel that heard Shelby County were 2 Republican appointees and 1 Democratic. And we knew where the Supreme Court was going with this because of Northwest Austin. But the 3 of us were pretty determined to decide the case under the current law the best way we could. We worked really hard on it. I talked about collegiality a little while ago. This was just a marvelous example of 3 judges with very different policy perspectives working together. Shelby County, from where I sat, was actually a remarkably easy case. And this leads me into what I want to say about the Supreme Court. It was an easy case because Section 2 of the 15th Amendment quite clearly and expressly gives Congress responsibility for enforcing the prohibitions of the 15th Amendment. That is, racial discrimination and voting. It's right there in the 15th Amendment. Section 2 is only 12 words, one of the most dramatic 12 words in the entire Constitution, because it completely changed the relationship between the federal government and the states. And so number one, it was quite clear from the Constitution who had responsibility for enforcing this act. And number 2, the Supreme Court had repeatedly said just that, going all the way back to South Carolina v. Katzenbach. The Supreme Court had said that. It had said, when it comes to race and voting, the courts owe deep deference to the decisions of Congress. That's where the Constitution vests that responsibility. So I didn't think it was a very hard case. You know, Congress had had extensive hearings, had made careful findings that Section 5 continued to be needed. And yeah, we had really good lawyers arguing against it, but what they couldn't get around was the fact that both the Constitution and the Supreme Court made it clear that unless Congress did something radically wrong and acted without any evidence at all, this was a choice we had to leave to Congress. So I didn't think Shelby County was a very hard case. It gets to the Supreme Court. What does the Supreme Court do on a 5-4 decision? Even though Section 2 gives this to Congress, even though Congress had found widespread evidence for the continued need of it, even though the Supreme Court's prior cases said that courts owe deference to the Congress, the Supreme Court said, this quote, "The South has changed." I mean, Congress didn't think the South had changed, and it was Congress that the Constitution gives responsibility for. So it was a fairly dramatic example of what I try to articulate in the book as to what I think is wrong with our current court. And well, let me just say one more thing about Shelby County. The other move the court made was it took a doctrine called equal sovereignty. Remember, under Section 5, certain southern states were treated differently than all other states. It took a doctrine called equal sovereignty, which the Supreme Court's own case law said applied only to the admission of states to the Union, had no applicability once they were admitted to the Union. It took that doctrine and used it to override the provisions of the 15th Amendment. So what you have here is a court that's second-guessing Congress and using court-made doctrines that it itself had said had no applicability here to override about as express a constitutional provision you can find. This is not like Roe v. Wade, where there's some debate about the underlying constitutional right. The constitutional standard is written in Section 2. There's no doubt about that. So this decision is, to me, emblematic of why I worry about our current Supreme Court. And it's basically this. It's that the court, in a series of decisions over the past 10 or 15 years, is too frequently abandoning the basic principles of judicial restraint, like faithfulness to constitutional and congressional text, its own precedent, limited jurisdiction. It's it's abandoned those. And as a result, you see in these decisions, 5-4 decision by 5-4 decision, now 6-3, steady growth of Supreme Court or judicial power over the two elected branches of government. That's threatening to the separation of powers, which framers of our Constitution believe were absolutely essential to protecting individual freedom. And it's dangerous to a democracy. And I try to make that case in my book based on these two sets of cases. Just to finish this off, this last week, we saw the same thing in the gun bump case, where the Supreme Court, in a statute that was ambiguous, instead of saying, how do we interpret this statute to promote congressional intent, they interpreted the statute in a way that produced a result directly contrary to what. That's what I think.
Judge, we are a little bit cutting into the question and answer time. Thank you so much. But I do, before we move on to question and answers, if we can just have a little bit of one more forbearance for one more question for the star of our show. Oh, there she is. So you got Vixen 5 years ago. I have to say that when I first heard you were getting a guide dog, my initial thought was that I felt so sad for your clerks, because we had this amazing opportunity to meet you in the mornings. We would take turns meeting you in the mornings at the Metro, and one of us would meet you and walk with you from the Metro to the courthouse. And we'd have this great opportunity to have this one-on-one time with you, talk about the news of the day, which I quickly gave up on ever reading the exact article in the New York Times that you were going to ask me about in the morning. But it was still this amazing experience to have this time with you. And I thought, geez, these poor new clerks are going to have to miss out on that experience. Now, however, of course, that I know Vixen, I'm just so thrilled that you made that leap. And can you just quickly tell us how that came to be? And, you say the last chapter of the book is entitled "The Dog That Changed My Life."
Yeah.
So tell us a little bit how that came to be and how did Vixen change your life?
Well, Jenny, I miss those conversations too after I got Vixen. They were really wonderful. I love those walks with my law clerk. It's really special. I'm going to answer your question about the dog that changed my life, but I want to remind everybody here that Vixen is a relative newcomer in my life. I've been married to Edie for 60 years. And if there's anybody who's responsible for whatever success I've had and functioning as a person with a disability, it's Edie. Now, Vixen has, and we are running out of time, but I'll just say this about the guide dog. Vixen has given both Edie and me a level of independence that we have not enjoyed in years. Because for a long time, I didn't use a cane. And so, I was getting around fairly well. But even with a cane, Washington was getting more and more dangerous, and the roads were more dangerous. And I needed a lot of help. As Jenny said, the clerks would meet me at the Metro. And at the end of the day, Edie would meet me, or someone would, because, Military Road or Western Avenue is a hazard, even if you have 20/20 vision. So what Vixen's done is Vixen has freed both Edie and me in quite dramatic ways. Everybody thinks that the guide dog, just services the blind person, but the fact is, yes, Vixen commutes to work with me. She's great on the Metro. She loves escalators. I don't need any help anymore. In the morning, instead of having to plan our day, when I would go off, Vixen and I say goodbye to Edie, and off we go. And she can have the kind of day she wants. And we then, at the end of the day, don't have to make plans to meet or anything like that. And that Edie and I now live in the country, in Castleton, Virginia. Vixen and I, we love to walk. Now, it used to be that I couldn't go on a long walk unless I could get Edie to go. Well, she likes to walk too, but she has other things she wants to do. Now, time for a walk. Vixen and I say goodbye, and off we go for 5 miles. Which means Edie is free to garden or read or just actually spend some time without me, which probably is helpful. The point is, Vixen has given us both this level of independence that's quite wonderful. And the other thing that she's done for me, and Edie, this is an observation Edie made a few years ago, is that Vixen's allowed me to walk, not just to go walking, but to walk alone. You know, aloneness is important. And I never was able to experience that because I was always with someone. And as much as I like talking with my law clerks, you know, you don't go for a walk from the metro to the courthouse in silence. You talk, right? So, but with Vixen, I don't have to talk. I can think. And in fact, I believe Vixen came right before we started writing this book. And I think, I truly believe that this book was not just, when Edie and I wrote this book together, and it was not just writing down what happened to us and, you know, our lives. It was actually thinking deeply about our lives together and the effect of blindness, not just on me, but on her and our marriage. And also, I thought deeply about the courts. And a lot of that thinking occurred on Long Mountain Road while I was walking along with Vixen. And so
Very good. So Joanna's going to take some questions from the audience. We have some microphones that will come around, and I'll just turn it over to Joanne from the podium. And
Thank you, Jenny, and thank you, Judge Tatel. Yes, so now's the opportunity to hear from all of you in the audience. So we have some roving mics. I see a hand back there. So we'll take 2 to 3 questions, and then Jenny and the judge can take those questions and address them.
Thank you so much for this wonderful conversation. My name is Evan Minot. I'm a litigator at the ARC of the United States. I also have cerebral palsy, and I'm curious. Sorry, I'm a little camera shy. Camera shy? I don't know. I'm curious. There seems to me to be a dearth of disabled lawyers, or certainly disabled lawyers who are out, quote unquote. And I'm curious, based on your experience, what does this profession need to do to be more welcoming to lawyers with disabilities?
Thank you for that question. Let's take one more question in the back.
Hi, Judge Tatel, John Greenbaum, fellow Lawyers Committee alum. So you don't know how happy those of us litigating the case were when you got both Northwest Austin and Shelby County. And thank you for the opinions, and thank you for reading almost the entire 15,000 page record. And it was interesting for me to read your thoughts about those cases. The title of the chapter is The Future of Democracy. And you talked a little bit about that a few minutes ago with respect to judging. I want to broaden and out a little bit in terms of the future of democracy in general. I'm concerned that our democratic norms have been bent and may break depending on what happens with upcoming events. And I'm interested in your thoughts about the future of democracy generally, even including the courts, but even beyond that, and what you think of the present state of our democracy.
So let me just take those 2 great questions in order. On the disability question, let me try to answer it this way, because I mentioned that, you know, when I was a young lawyer at the Lawyers Committee and at Sidley, you know, I worried about whether a lawyer with a visual disability would be able to get a good job. I didn't know. I had lots of wonderful role models, civil rights role models, great lawyers, but there were no blind judges. There were no blind partners in law firms. There was nothing like that. I mean, you think it's bad now. You know, when I was dealing with these issues, there were, I knew of no blind lawyers. I didn't even know of any lawyers who had any disability of any kind. There's a lot of reasons I wrote this book, but I think one of the main reasons was, as I look back on the experience, is that I hope that by telling my story, maybe a young lawyer, in a law firm, worried about a disability will read this book and think, I can do it. And even more important than that, I hope that hiring partners in law firms read this book, and CEOs of people who hire other people. I hope they read this book and realize that if they're filling a job and they have 3 candidates and one of them is blind, or one of them is in a wheelchair, or one of them can't hear well, that they make the decision based on the merits. That's what I hope my book will help. That's a big hope, but maybe in a small way it will help. So John, on your question, when I talk about the threat to democracy, I mean not just all the voter suppression that's occurred after Shelby County, but probably even more important, the threat this court itself poses to democracy. We have an unelected court, which I think a life tenured judiciary is one of the most important decisions the framers of the Constitution made. I think that the success of our democracy is to a certain extent attributable to a life tenured judicial system that focuses on the protection of the minority from the oppression of the majority. The irony is that the power of the judiciary can also threaten the same democracy it's preserved. And my worry now is that as the unelected court increases its power over the political branches of government, that it's fraying our fundamental democratic values. Now, I don't know the future, John. This country has faced serious challenges before, and I hope we will survive this one also. But I think it's going to depend on, it's going to all turn on citizens voting and voting for the right people, and it's going to take a long time. But this democracy survived for 2.5 centuries, and for good reason. And fingers crossed. I don't know what else to say, except that you and the other litigators need to keep going. That's what you need to do. The Lawyers Committee, particularly with this election coming up, is now more than ever do we need really good voting rights lawyers who could protect the integrity of the voting system.
There are other questions in the room. Wow, I think you've managed to silence a room full of brilliant lawyers. But I want to thank Judge Tatel, Jenny, for this very rich, meaningful conversation. I cannot wait to dig my teeth into your book. For those of you who are interested in the book, Judge Tatel has signed books. There are books outside this room that are available for purchase. Sidley Austin is generously hosting a reception that we invite all of you to attend. I again want to thank our hosts here at Sidley Austin. I want to also thank our esteemed guests. We were joined during the event by the Chief Judge of the DC Court of Appeals, Anna Blackburn Rigsby, who's also here with us. That's a special thanks.
Oh, good graduate, by the way.
Yes. And of course, our deepest thanks to Edie, to Vixen, and to Judge Tatel for gracing us with your stories and your presence. Thank you again, and enjoy.